is here, that challenges the authority of the federal government in one area. One federal court has said it's unconstitutional. I think that judge is wrong. Unfortunately, we're in the Ninth Circuit. I don't think we'll get to win in the Ninth Circuit, but I think we have a chance of winning in the United States Supreme Court. But I think you can pick any given area where the federal government is exceeding its power, pick a fight with them, and then go litigate the issue and begin to demand that the federal government acknowledge that the Constitution provides only limited powers to it. I think that's one example, and there are lots of others.
Anybody else want to address that? Okay, let's go to the first microphone. Please introduce yourself and please be brief.
Sure. Roman Bueller from the Madison Amendment Coalition, and this is a question for Congressman Bishop. You gave a very, very persuasive speech to the Federal Relations Task Force yesterday on behalf of your bill, the Madison Amendment Bill in Washington, based on Ed Meese's original idea that states ought to have the same power as Congress to propose amendments. I wonder if you could tell us a little bit about the bill and why you're leading the charge.
Actually, it's John Culberson's bill. I'm just one of the co-sponsors with it. It's bipartisan. The idea goes back to Article 5 gives the federal government, the legislature, the ability, Congress, the ability to start constitutional amendments. The only thing states have to do, and this was something Madison wanted as a counteroffer to the legislature, or to Congress, is to call a constitutional convention, which scares the crap out of everybody. So the Madison Amendment is simply saying that 2/3 of the states, if they pass an amendment to the Constitution, verbatim, just an amendment, can therefore start the process of sending that to the states for ratification. So it simply will change Article 5 and give the states another tool. Whether you use it or not is insignificant. The significant part is states have another option, which is why we like the Madison Amendment. It doesn't involve calling a constitutional convention, which scares people. It limits it to a specific topic, but allows states to bypass Congress. It's an effort to try and empower states. We hope you guys will support that one as well, and we'll see how far we can move it in, obviously, a couple of sessions we'll need.
Okay, the second microphone.
My name is David Biddulph. I'm with the Vote on Taxes Committee, and I'm wondering what your view is about the states moving forward with an Article 5 process to basically propose amendments to the Constitution that put the federal government back in the box.
Well, I thought I just did. Yeah. But you know, the Madison Amendment would be a way of giving another vehicle for states to work towards changing the Constitution. I would also hope that as you, especially the state legislator that spoke originally, if you make sure that the kinds of things that you have written down, if you can get that to us so we can make ways of seeing how the 10th Amendment Task Force can try and work with states to accomplish the same goals if we're working from the same level, from different levels towards the same goal, would be very helpful. But also anything that can happen on a legislative level. I mean, Bruce Babbitt, when he was governor before it became strange, came up with the idea that if there's a mandate the states have to accomplish, if 2/3 of the states pass a resolution to repeal that mandate, it's sunsetted within a year, and Congress has to redo this entire concept. Those are the kinds of things I'd like to try and push from Congress, and if we can work with you pushing from the states, we can work together.
Okay, the first mic.
I'm Carl Wimmer, State Representative from Utah. I got a question for both Representative Shadegg and AG Kinder. First, Congressman Shadegg, in reference to your Enumerated Powers Act, and I'll ask both questions and I'll sit down and let you answer them. Your question is, in reference to the Enumerated Powers Act, it's a great idea, but I fear that under the current interpretation of Article 1, Section 8, the enumerated powers, especially the Interstate Commerce Clause, when you're dealing with Wickard v. Filburn and Kirschbaum County v. Walling, these interpretations that the Supreme Court has allowed to occur under interstate commerce, all you have to do now is say it's allowed under the Interstate Commerce Clause. So I wonder what your answer to that would be. And to you, Attorney General, under Article 3, Section 2, Clause 2, it talks in the Constitution about how when a state is involved in a lawsuit or is involved, they're a subject or a principal in a lawsuit, that the Supreme Court has original jurisdiction. So I'm wondering, in your opinion, how in the world did a federal judge overturn anything that Arizona did when they were a principal in that lawsuit? They were the principal there, and under the Constitution, in Article 3, the original jurisdiction should have went right to the Supreme Court rather than to a federal judge. So I'm wondering about that. And as one of the founders of the Patrick Henry Caucus, thank you for mentioning it, and please stop by our booth, which is 409. Thank you.
Let me try to briefly answer your question. First of all, I think there are many reasons to be very worried that the Enumerated Powers Act would not necessarily completely solve this problem. Had I introduced what I would like to see happen, I would introduce something that says no act enacted by Congress in violation of any enumerated power is in fact constitutional, and have them automatically thrown out. I would love to have gone much further than the Enumerated Powers Act goes. I did not delude myself when I introduced it into believing it would in fact solve all the problems. Indeed, all we said was that you get a point of order and you have the right to debate it. My view is we have drifted so far from the correct interpretation of the Constitution, under which the federal government only has those specific 18 enumerated powers, that the fight to take it back needs to be an incremental one. This is one piece of many. Indeed, a part of it is, having served in Congress, you discover that the vast majority of members of Congress have no concept that they don't have unlimited power. Pete Stark represents the vast majority of members of Congress. I would argue virtually every member of Congress on the left already believes that, and many on the right have never even thought of it. So what we were trying to do is one step by one step. I also wanted to take away from opponents of the idea the concept that, well, Congressman, you'd undo everything that Congress has done for the last 40 or 50 years. I didn't want to have it not get a hearing or not be enacted for that reason. Now, you can argue I made a mistake because, having written it in its most modest form, we still didn't get a hearing or get it passed. I would point to some Supreme Court decisions, both the Prince decision and the Lopez decision, and a series of others. Prince, you know, is the Brady gun law provision, where the federal government treated local law enforcement and sheriffs as their employees and said, you shall conduct background checks. And a sheriff in Arizona and others said, we don't work for you. We work for the people that elected us. And they won that case. So under the provisions of the Enumerated Powers Act, those of us who believe the Constitution, it reads as we argue in this room, would get to debate that on the floor. It would go to the U.S. Supreme Court, and I would have to hope then the Supreme Court would begin to say, that's right, all power isn't vested in the states. But in an incremental fight where you do one battle after the next, if the Supreme Court didn't do that, then of course you'd have other chances. One would be further legislation, but one would be a constitutional amendment. What I would argue to you is that a constitutional amendment is very hard and almost impossible to get without laying the predicate. And the predicate here is Congress has overstepped, the federal government has overstepped its bounds. We need to take that power back. But your point's absolutely well taken.
Congressman, if I'm not mistaken, the Lopez case was a gun-free school zone case.
That's right.
San Antonio, which the federal government passing the gun-free school zone law said, we can do this under the Commerce Clause. And Mr. Justice Scalia, writing, thank goodness for 5 members, I guess, in the majority, said nope. The state government might do that. We have no opinion on that, but the federal government Commerce Clause is not unlimited. You can't do that under that. Okay, and we like the Lopez and the other case you saw, the Prince case line of jurisprudence for our arguments. But want to correct one thing. I'm not the Attorney General. I was in law school and did pass the bar one time 30 years ago. And my con law class was in the late 70s, and I'm not really competent to answer your question, okay? It's just been too long. You'd need a panel of law professors up here to debate that esoteric point.
Okay. We will take your question, but while we are, don't forget, if you haven't filled out the card, fill out the card. We want to make sure that if you don't have a card, you can have mine, okay? So come up front afterward. Fill it out so that we can keep you informed. Don't forget to go to the website, join the 10th Amendment Coalition, get involved. And now your question, please.
Hi, I'm Bill Fruth with the 10 Amendments for Freedom. I just wanted, perhaps the other panelists might want to clarify the Congressman's opinion that Article 5 only provides for a constitutional convention, because there's no mention of that in Article 5, that it's an amendments convention for proposing amendments. And the opinion of many is that it can indeed be limited to just proposing amendments, and perhaps the Madison Amendment isn't a. But do the other panelists have an opinion on the procedures and being able to limit an Article 5 convention?
If you want me, look, I don't disagree with what you're saying there right now. The problem is, if you try to do anything with Article 5 right now, every group from the right comes unglued because of what they think may happen, and since there is no precedent, it may indeed be true. What I think we should do is try and rewrite Article 5 so that it's very clear that states have a specific power that doesn't give a lot of fear to other people who you don't need to fight those fights.
So it's an educational issue, basically.
Yes.
Please join me in
Wait a
thanking.
minute,
I'm sorry,
I
go
don't
ahead.
want to just add,
Can I make one final?
Sure, of
the
course.
problems with Article 5, in fact, are restricting the powers of the state. And anything that would clarify it, I mean, all Americans or many Americans involved in this debate are fearful of a convention, perhaps improperly so, but nonetheless. And therefore, anything that we can do to empower states to engage more aggressively with a federal government and to reset this balance, you asked if we had an opinion, I think that's a good step. If Article 5 is currently misapprehended, so be it. What we have to do is continue this fight, and on any front we can. 1070 is one of those fights, limiting the federal government's ability to say to the states, well, here's federal money, but you have to spend it exactly the way we tell you. Anywhere we can pick a fight with the federal government, we ought to be picking a fight, and any power that we can get granted to the states, including the one that's proposed by Mr. Bishop, or actually by our colleague Congressman Culberson, is a good fight.
So you're looking toward Congress proposing the Madison Amendment, as opposed to attempting to have an Article 5 convention for the purpose of amending Article 5. All right.
I want to make one more point that I think is very important. We're all sort of the prisoner of the immediate onrush of events on any given day, week, month. One of the biggest threats to the states and to our freedoms is the post-election lame duck session of Congress. Newt Gingrich at American Solutions, and if you're not following him on Twitter, you should be. And if you're not following AM Solutions, I think it is, AM Solutions, which is American Solutions on Twitter, you should be. They are pushing back aggressively against this lame duck session of Congress and insisting that members of Congress just say no to the lame duck session. Now, what I think we can do is put pressure on Democrats back in our home states. We have one very conservative Democrat in Missouri who's experiencing his first re-election challenge ever, and that's Ike Skelton. He's been there since 1976. He's chairman of the Armed Services Committee. And I tweeted this morning to my 1,984 followers that I dare Ike Skelton, Russ Carnahan, another member of Congress who I think we got a great shot at beating this year in Dick Gephardt's district south of South St. Louis, and our junior senator, Claire McCaskill. I dare all three of you to go to that lame duck session of Congress and enact the Nancy Pelosi agenda. And I think if we put them on the defensive that way, we can win this battle too, in facing them down. There are enough Democrats that if we put that pressure on them, they will buckle, I think.
Now, please join me in thanking our excellent panel.
I hope I didn't
And enjoy your lunch.